Hi, everyone. Thank you so much for being here today. My name is Elizabeth Schwartz. I'm the chair of the Miami-Dade Gay and Lesbian Lawyers Association and one of the team members that put this event together for you. We planned the timing, the victory, the language. I sort of ghost wrote Justice Scalia's dissent for him, whatever, perfect roadmap to challenging the marriage ban in the state of Florida. So we worked it all out for your convenience. We're so glad to be a part of this incredible week, to be able to celebrate together after this these historic decisions that you'll be hearing more about today. But I just wanted to quickly welcome you. This event is a co-production of the Miami-Dade Gay and Lesbian Lawyers Association, the Central Florida Gay and Lesbian Lawyers Association. Hi, Mike Morris. Thank you for representing Central Florida. And the Gay and Lesbian Lawyers Network, which is a Broward County organization. And Neil is going to welcome you in a moment. And Leah Krause is their head. Hi, Leah. Thank you for being here. And we also got incredible support from the Equal Opportunity Law section of the Florida Bar. We got funds directly from the Florida Bar, which just goes to show how supported we are here. We're going to be hearing a little bit later for a few moments from Ray Abedin, who's a member of the Board of Governors. And we also got wonderful support from Mass Mutual. Where's Ashley? She's somewhere. Thank you. Hi, Ashley Kaczynski. Thank you, Mass Mutual, for your support. This event was put together by a really hardworking committee. Jessica Blackman is here. Thank you, Jessica. She's been so awesome dealing with the hotel. Kim Bird from Tampa wasn't able to be here, nor is Rusty Mead from Jacksonville, or Mary Wakeman from Tallahassee, nor is Blaine McChesney from Orlando. But they worked so hard, and you wouldn't believe how much work it is to throw a little couple of hour event together. But we are sort of we're a group of LGBT lawyers that want to be sure that we educate ourselves and one another, members of the bar, about important legal issues as it regards the LGBT community. We did a seminar last year, also in conjunction with the Florida Bar's annual meeting in Orlando, called Out of the Office and Into Your Closet, Effective Representation of the LGBT Community. And out of it, what did I say? Out of the office into, oh, that was personal. Out of the office. Out of the office, out of the closet, sorry. Out of the closet and into your office, effective representation of LGBT. I'm glad someone's paying attention. Can you tell I'm like a little exhausted after this week? I'm barely standing, and I'm really sick of the sound of my own voice, so I will be brief. But our next event is in Jacksonville. And it is not in conjunction with the Florida Bar's annual meeting, because this is it, but we are off the Florida Bar calendar because we have so much support from the Jacksonville LGBT community, and specifically from Florida Coastal School of Law. So the event is October 18th and 19th. It's going to be a 2-day long CLE on LGBT issues. There's a website, closettooffice.com. Boom. So Rusty Mead has been working so incredibly hard putting that together with her incredible team in Jacksonville. So please put that on your calendars. This today is just an hour, and it's just a taste of some of the information that we want to make sure that everyone has. The event, October 18th and 19th, is going to be a little bit more substantive. Like we did last year in Orlando, we're going to be covering all kinds of topics as it relates to representation of the LGBT community, family law, estate planning, real estate, bankruptcy, criminal, immigration, you name it. We're going to be talking about it. Let's see, a couple of just little housekeeping items. The restrooms are to the right in front of the FedEx office. And we are happy to have two incredible speakers today, and they are willing to entertain questions during and after their remarks. But we are going to have you guys take the questions from here, because we are recording this and the microphone is connected somehow, I don't know, whatever. So the questions have to be from up here. So if you have a question, burning your own question, feel free to interrupt, but you guys stay here.
We'll just repeat them.
Exactly, thank you. Let's see, the CLE number, get a pen, it's posted outside if you don't feel like writing it down now, but I'll just tell you. It is 1304716N. 1304716N.
Bingo.
And that assumes you're staying for the whole hour, so we're going to lock the door so you can't leave, okay? So let's see. I want to just briefly introduce our second speaker, but so I can sit down and shut up. And his name is Daniel Tilley. And Daniel is a staff attorney with the ACLU of Florida. And Daniel has the distinction of being the only attorney working for a nonprofit in the state of Florida full-time on LGBT issues. So his focus is 100% on LGBT issues, and he is the only one doing it for any of our nonprofits. And he started not long ago, but he's already made a big impact, and he's just a super great advocate. He went to law school at the University of Georgia, and he went to undergrad at NYU, where he majored in piano performance, and he minored in the German language. Das gut. And by the way, I know you're noticing how adorable he is. So I will say he has a partner, but the partner lives in Georgia. So I'm just saying. It's just been a little over a year. So look at me, such a homewrecker. So, anyway, so I'd like to welcome Neil Kollner to introduce our other speaker, Judge Olson, and thank you all for being here.
Thank you, everybody. As Leah said, my name is Neil Kollner. I'm the Vice President of the Gay and Lesbian Lawyers Network in Broward. And those of you who are not members, we invite you to join. There's no geographical limit. You could be wherever you live and you can join us. And we're not limited just to lawyers. We have law students, business affiliates, and legal workers and professors, etc. So anyway, welcome to all of you. Fortunately, this is a happy, momentous, and timely discussion on marriage equality. As we said when we started to plan this, we didn't know whether we were going to be celebrating or grieving, but fortunately we are celebrating. We especially would like to thank the Florida Bar, particularly Arnell Bryant Willis, who is the Diversity Initiatives Manager, and the Equal Opportunities Law Section for their generous sponsorship, staging the event, and the reception immediately following across the hall. So please stick around for that, because we're going to have a couple hours so that you can meet everybody and discuss these issues more in detail. I think I better put on my glasses. I'm pleased to introduce the Honorable John Carl Olson, a member of the Gay and Lesbian Lawyers Network, who among his other activities, at his own expense, filed a Supreme Court Amicus Curiae brief in the United States versus Windsor case and attended the oral argument at the Marble Palace. Judge Olson was appointed in February 2006 by the U.S. Court of Appeals for the 11th Circuit to serve a 14-year term as United States Bankruptcy Judge for the Southern District of Florida with his duty station at Fort Lauderdale. For the 18 years before that, he was a shareholder in the Tampa office of Stearns Weaver Miller, a graduate of Harvard College, magna cum laude in history. He wrote his senior thesis on Cambodian foreign policy toward China from 1955 to 1965.
Perfect preparation for being a bankruptcy judge.
He graduated from Boston College Law School, where he was on the Law Review in 1975. He's a former chair of the business law section of the Florida Bar and serves as the chair of the Abuse of the Bankruptcy System Subcommittee of the Business Bankruptcy Committee of the American Bar Association. I think he knows a little bit about that. His November 2010 marriage to Stephen Fender was announced on the weddings celebrations page of the New York Times. Apart from the overall decision in Windsor, I am certain Judge Olson and his husband are both pleased that the federal crime of assault on the member of the immediate family of a United States judge now explicitly protects Stephen.
Do you all mind if we sit down? It's kind of hard to have dialogue, but I don't want to be in a position where you all can't see us. Which is better, standing or sitting? Oh, the courtesy they all extend. Well, first a disclaimer. anything I say can't be used against me in my courtroom. DOMA Section 3, which is the provision that was up before the court, amended Title I of the United States Code, Section 7, to define marriage as between one man and one woman. Title I is the dictionary section of the United States Code, and this definitional change affected some 1,110 or 1,183, depending on whose numbers you use, separate federal statutes. And it was the only time that the United States has attempted to define marriage, otherwise deferring to the states. Windsor found Section 3 unconstitutional in very broad and sweeping language. This is a happy week for equal protection and for liberty. I can't honestly discuss Windsor without sharing how DOMA affected me personally. Steve and I were married in November 2010, and immediately thereafter I applied for a judicial survivor's annuity system annuity to provide for Steve after my death. I'm 20 years older than he is, and while we both have forebears who lived well into their 90s, odds are pretty good that he'll survive me by some period of time. I filled out the forms and I instructed the administrative office to take 2.5% of my salary out of my pay, and they did that for 4 months before I got a phone call and a letter that said, governing law does not currently permit your enrollment in JSAS based upon a same-sex marriage. I was pissed off. So when cert was granted in the Windsor case, I was eager to be heard on the subject. And my very dear friend Eric Brunstad, who is one of the superb appellate lawyers who's argued 10 cases in the Supreme Court and been involved in 30 or 40 others, was looking to participate in this discussion as well. And he, on my behalf, filed briefs on both the substance of the DOMA case and the jurisdictional issues. I can tell you that the brief on jurisdiction is something that even a lawyer could be put to sleep by. So if insomnia is your problem, get a hold of it, and some late night you can try reading it, and good luck. A word about briefs. Briefs in support of the respondent in the Supreme Court on the merits are in dark green. Briefs in support of petitioners in the Supreme Court are in light green, and everybody has a different color depending on what it is. My briefs and all of the briefs in this case are available online. Go to the Supreme Court website, hit Merits Briefs. It'll kick you out to the ABA website, and just scroll down. You'll find US v. Windsor, and you'll find 85 or so merits briefs and jurisdictional briefs. Eric commented on the Windsor case in a posting he put up a few days ago. He said, "For me, the decision reads like the Supreme Court's opinion in Brown versus Board of Education. It's an amazing discussion of equality and inclusion. Like the decision in Brown, it basically avoids a lot of doctrinal analysis. For example, missing are the usual statements in debate about the level of scrutiny applied to evaluate suspect legislation, strict scrutiny, heightened scrutiny, rational basis, and other legalese. Instead, what we have is a distilled and sweeping pronouncement that enough is enough already, and the time has come to shed an old form of bigotry. It's a vindication of liberty expressed in noble and towering rhetoric. It's really moving and powerful and beautiful and healing. I'm very grateful to John and Steve for giving me the opportunity to participate in this case on their behalf." I think Eric got it right in his comments. Justice Kennedy's opinion is not a hyper-technical, lawyerly clever textual exegesis. It's instead a broad, sweeping statement that Congress may not discriminate against a minority and must recognize the dignity of same-sex marriages, recognize by the states which permit them. To do otherwise, Justice Kennedy held and the court found, violates basic due process and equal protection principles. His opinion has the following. DOMA's principal effect is to identify a subset of state-sanctioned marriages and make them unequal. The principal purpose is to impose inequality, not for other reasons like governmental efficiency. Responsibilities as well as rights enhance the dignity and integrity of the person. And DOMA contrives to deprive some couples married under the laws of their state, but not other couples, of both rights and responsibilities. By creating two contradictory marriage regimes within the same state, DOMA forces same-sex couples to live as married for purposes of state law, but unmarried for the purpose of federal law, thus diminishing the stability and predictability of basic personal relations the state has found it proper to acknowledge and protect. By this dynamic, DOMA undermines both the public and private significance of state-sanctioned same-sex marriages. For it tells these couples and all the world that their otherwise valid marriages are unworthy of federal recognition. This places same-sex couples in an unstable position of being in a second-tier marriage. Or as Justice Ginsburg said at the oral argument on March 27th, skim milk marriages. For certain married couples, DOMA's unequal effects are even more serious. The Federal Penal Code makes it a crime to assault, kidnap, or murder a member of the immediate family of a United States official, a United States judge, or federal law enforcement officer with the intent to influence or retaliate against that official. Although a spouse qualifies as a member of the officer's immediate family, DOMA makes this protection inapplicable to same-sex spouses. And the list of rights and responsibilities that are unavailable to same-sex couples under DOMA goes on and on. Justice Kennedy's position on DOMA was actually entirely predictable. He was the court's author of the court's opinion in Lawrence v. Texas, which in 2003 held that state statutes prohibiting consensual sex between same-sex adults were unconstitutional violations of fundamental rights of due process and privacy. But think about that. It was only 10 years ago that state laws criminalizing sexual activity for lesbians and gay men were found unconstitutional. Lawrence stirred up immediate and vitriolic criticism, none of it feistier than that from Justice Scalia. And in Justice Scalia's dissent in Lawrence, he made some statements that I found to be 100% accurate. He wrote that the Supreme Court's holding that state sodomy laws were unconstitutional would lead inevitably to same-sex marriage. Thank you, Justice Scalia. You were right, and you helped set a goal for the LGBT community, which is now realized for the first time in the Supreme Court in Windsor. And I believe that Justice Scalia is right in his dissent in Windsor, that the court's ruling there will lead inevitably to the systematic dismantling of state laws which prohibit same-sex marriage. But while what Justice Scalia sees as a path which violates his notion of traditional morality, many of us see as a path to equal protection. That path is likely to be difficult. For while the evolution of public attitudes, and especially demographic trends, suggest we'll get to the point where the country as a whole provides us with legal equality,
the fight is certainly not over. Part of the exercise is public education. In 1986, a mere 27 years ago, the Supreme Court upheld state sodomy laws in Bowers versus Hardwick. Justice Lewis Powell, by all accounts a very decent human being, concurred in the result, but didn't think that the case was very important. Indeed, he told one of his law clerks, who happened to be gay but entirely closeted, that he had never met a homosexual. When I came out, I was already serving on the bench. I came out as noisily as I could, partly because I wanted it to be an interesting story in the bar for about a day, and partly because I wanted to be a public witness to the unquestionable truth that gay people are everywhere, fully engaged in society and performing good work, and that for those purposes, sexual identity is entirely irrelevant. And so Steve and I did, in fact, put our wedding announcement in the New York Times. Part of realizing our community's dream of full marriage equality requires brave litigants like Edie Windsor to push the remaining legal obstacles down the path. And Justice Scalia's dissent points out where some of those problems will be. Imagine, he writes, a pair of women who marry in Albany and then move to Alabama, which does not recognize as valid any marriage of parties of the same sex. When the couple files their next federal tax return, may it be a joint one? Which state's law controls for federal law purposes? Their state of celebration, which recognizes the marriage, or their state of domicile, which does not? Does the answer depend on whether they were just visiting in Albany? Are these questions to be answered as a matter of federal common law, or perhaps by borrowing a state's choice of law rules? If so, which states? Let me put this controlling law question in a personal framework. As I said in the beginning, I applied for a judicial survivor's annuity in 2010. Steve's and my marriage is valid under the laws of the Commonwealth of Massachusetts, where it was performed, and it's valid in the state of Maine, where we have a vacation house. It is, of course, not recognized here in Florida. Will the Administrative Office of the United States Courts recognize us as legally married for JSAS purposes? I asked them that question on Wednesday morning at approximately 11:45. It took me an hour and a half to get the letter out, but I was on the bench for part of that time. And I asked them to enroll me immediately. I haven't had a response, but I hardly expected one in 48 hours. President Obama yesterday said in a news conference in Senegal, and I quote, "It's my personal belief, but I'm speaking now as a president, not as a lawyer, that if you marry someone in Massachusetts and you move somewhere else, you're still married." Good choice of states, Mr. President. Much has been said about the motivations of those who enacted DOMA and who even now oppose gay marriage. Chief Justice Roberts asked Edie Windsor's lawyer at oral argument on March 27th, a mere 90 days ago, if she believed that all of those who voted for DOMA were bigots. She said no. I wish she'd gone a little further and said no, that politicians are largely motivated to do that which is expedient. As my merits brief in Windsor makes clear, the zeitgeist, the spirit of the moment, the political context in which DOMA was enacted was clearly inspired by fear and hatred. A level of fear and hatred which infected the contemporaneous political culture when segregationist laws were adopted, or laws demeaning to women or aliens. It's my belief that even good people in public office will usually do that which is expedient. Indeed, Stephen Colbert said on Wednesday night that, quote, DOMA was enacted in 1996 to guarantee that traditional marriage was between one man and one woman for the sacred purpose of getting Bill Clinton reelected. It is today no longer broadly expedient to oppose same-sex marriage, at least in public and in enlightened parts of the country. We can hope to move hearts and minds, and Windsor will help considerably by putting the moral force of law behind the notion that same-sex marriage, and further that gay men and lesbians, are okay. We won't turn every heart. Private bigotry will always be with us. Right, Paula Deen? But by taking incremental steps in litigation and in legislation, the rights of the LGBT community will increasingly prevail. It's really ironic that our collective wish to be allowed to join the most conservative social structure in the world, marriage, is the engine pulling gay men and lesbians into social acceptability. It's been a wild ride from Stonewall in 1969, when I was a rising college junior, to Windsor. May our progress continue. Thanks.
All right. So I'm going to talk about a decidedly much less sexy case, the Prop 8 case. So I'll talk about that for a little bit, and then I'll talk about how the DOMA decision affects folks here in Florida. Can the people in the back hear me? Okay. So in 2008, the California Supreme Court held that limiting the official designation of marriage to opposite-sex couples violated the Equal Protection Clause of the California Constitution. At the time, folks could get could register as domestic partners and get all the benefits of marriage, at least all the state benefits, but not the word marriage. And so the California Supreme Court held that that violated the state constitution. So for a limited time in California, same-sex couples could marry. Then, of course, later that same year, Proposition 8 came about. That was a ballot initiative that amended the California Constitution to restrict marriage to opposite-sex couples. There was a procedural challenge that went to the California Supreme Court. It was rejected, but they said the old marriages, the old same-sex marriages that occurred between its original decision and the passage of Prop 8 were still valid. So two couples filed suit in May 2009 in federal district court in California. Chief Judge Vaughn Walker was the judge then, and he issued a decision in August 2010. Very broad decision that was very expansive, protective of rights. He found that that Prop 8 violated the federal constitution, violated the Equal Protection Clause of the federal constitution under the rational basis test. He didn't go for heightened scrutiny. And it also violated the due process clause. He said there was a fundamental right to marry. He cited Loving versus Virginia. So he went all out in this opinion after a 12-day bench trial. And the state in that suit had refused to defend, so the 5 proponents of Proposition 8 were left to defend it. They appealed to the Ninth Circuit, and in January 2011, the Ninth Circuit certified a question to the California Supreme Court saying, do official proponents of an initiative measure have either a particularized interest in the initiative's validity or the authority to assert the state's interest in the initiative's validity when the public officials charged with doing so don't do so? 11 months later, the California Supreme Court said, yes, they do. And so then in February 2012, the Ninth Circuit issued the opinion everyone was waiting for. They unanimously found that there was standing, that the proponents did have standing to appeal the decision, but they split 2-1 on the merits. So the case that was filled the decision was the case in Romer versus Evans. This was a case decided in 1996 by Justice Kennedy. It was a 6-3 decision that included Justice O'Connor. And in that case, this in the 90s in Colorado, a few cities had started passing ordinances protecting gay people in employment and housing and public accommodations. And the people of California, I guess other people of California, didn't really like that. And so they started a ballot initiative there and created a constitutional amendment that banned cities and states and all the political subdivisions from passing laws to protect gay people. And that was challenged, and it went up to the Supreme Court, and in an opinion by Justice Kennedy, he said animus is not a proper basis for this type of legislation, and therefore the ballot initiative was unconstitutional under the Equal Protection Clause. And so, in the majority opinion in the Ninth Circuit, this was really a Romer decision. It was a love letter, basically, to Justice Kennedy, trying to give him a way to rule narrowly in this decision without making a 50-state solution where he had to make this broad pronouncement that denying same-sex marriage is a violation of the federal constitution. He said, well, California gave marriages to gay people before, but if you take away that right after you've given it, that's a violation. And so that's what the opinion was about, and that's how it came up to the Supreme Court. It was a much narrower decision than the district court opinion, but that's what it was. So what did the Supreme Court hold? They didn't talk about any of that. They talked about standing. There's not, I think, one word in this opinion about the merits of the case outside of the dissent. It is entirely about this very technical issue of standing. They say to have standing, you need a concrete and particularized injury that is fairly traceable to the challenged conduct and is likely to be redressed by a favorable judicial decision. They said, well, plaintiffs had standing initially because they were injured, they couldn't marry, they wanted to marry, they filed suit, okay, they won. So it wasn't their place to appeal. The proponents had to appeal. But the Supreme Court said the proponents had no direct stake in the outcome. They just had a general interest in vindicating the constitutional validity of a generally applicable California law.
And the curious thing about that part of the decision is that California has a peculiar constitutional system that says that proponents of a ballot initiative have higher degrees of rights to protect the result of the ballot initiative than anybody else. And under the California constitutional scheme, which believes strongly in direct democracy, the proponents have a higher degree of right to defend the legislation that they caused to be passed. The Supreme Court really didn't talk about that, and that strikes me as really quite odd. I thought that this was a federalist Supreme Court, and I guess it's federalist when it suits them. Now, for us who aren't really unhappy with the result, we're not going to be complaining too much about that. But it is a strange little bit of constitutional law.
Sorry. Right, no. Thank you. So, I mean, there are provisions in the California Election Code that grant these higher rights and interests of the proponents to engage in litigation or to defend the validity of the act. But the Supreme Court wasn't having it really, and they said, well, even if you have certain rights to enact the initiative, that doesn't mean you can enforce it. That doesn't mean you have the interest in enforcing it. They looked to the restatement of agency. They said these elements don't exist. The proponents don't answer to anyone. There's no fiduciary relationship. There's no accountability. They decide, not the state or the attorney general, what arguments they're going to make. The people can't remove them from their role. So they said there's no real agency relationship here. They're not representing the state. They don't have a direct stake in this. So no standing.
And the restatement of agency is more important than the statutes of the state of California.
And the unanimous opinion of the California Supreme Court on that specific issue. So the dissent really took the majority to task in this case. And they talked about the practical implications of what this means. They said, well, you're basically giving a veto to the governor and the attorney general over initiatives that are found unconstitutional because they can decide that they can't be appealed. They said a primary purpose of the initiative process is to give the people the power to enact legislation that their elected officials won't enact, won't adopt, or they refuse to, or they will decline to. And so this purpose is undermined if the very officials that the initiative process seeks to circumvent are the very ones that are going to have to defend the lawsuit. So they really accuse the majority of warping the standing rules for the purpose of avoiding a merits discussion of this case. And the split was quite interesting. This was not a typical 5-4 split. This was not the Windsor split.
Hate to use this analogy, but very strange bedfellows.
So the finding of no standing was from Roberts, Scalia, Ginsburg, Breyer, and Kagan. And the finding of standing, the dissent was written by Justice Kennedy. He wanted to reach the merits in this case, which raises a lot of questions. But the dissent was written by Kennedy and joined by Thomas, Alito, and Sotomayor. So it's a very peculiar split, and we could talk all day about what it means. I mean, traditionally, the more liberal justices are seen as wanting broader standing requirements, wanting people to be able to file grievances and get into court, and conservatives are seen as wanting more narrow standing requirements. And so there's some belief that those kind of divisions are breaking down. You know, one can question, you know, you could ask whether this is a manifestation of that or if there's something else going on. It is interesting that Kennedy really wanted to get to the merits, and maybe he really wanted to have a 50-state solution, but maybe he also was just willing to take the bait of the Ninth Circuit and say, well, in this one specific context where you've granted a right and are taking it away, I'm okay with that. That would have been a California solution.
But he is from California.
But he is from California, right? So you know, it's unclear what this is going to mean for future litigation. Certainly, in the standing area, it means that it'll give more power for state governments to do away with state ballot initiatives, and apparently those challenges are not that uncommon. But so it brought back same-sex marriage to California, which is obviously a huge victory for the movement, and more state constitutional amendments are going to fall as time goes on, and this is a huge step forward. There was a procedural barrier in this case, the standing issue, but there are 5 other federal lawsuits going on right now that won't necessarily have those procedural barriers. So you could see a Perry-like case at the Supreme Court in a few years again. There are cases that are well litigated. 2 of them are in the Ninth Circuit right now. So, I don't think it'll be too surprising to see a case like this at the Supreme Court again without this impediment. And in the meantime, I think the goal for all of us, at least those who are interested in seeing marriage continue to expand, is to continue to change the map. In states where it can change, to change it there, and in states where it's less likely to change, continue to work to put other protections in place. And so I guess that's what I have to say about Perry for the moment, but I also want to talk about the implications of the DOMA decision. So
Before you do, can I ask you about Perry? Am I correct that one of the reasons the district court judge in Perry found that the ballot initiative violated the Constitution was there was already a right to marry that was taken away, and therefore that was something that you could not do? It would perhaps have been different if they had not already had the right to marry.
that was the premise of the Ninth Circuit decision. Absolutely. There may have been a line in that in the district court opinion. I'm not positive. Go ahead.
And that's pure Romer.
Okay.
That's pure Romer. That's what Kennedy said in the Colorado situation. That didn't deal with marriage, but did deal with other protections for gays and lesbians.
And in the Ninth Circuit opinion, Judge Reinhardt said, "This is not the first time the voters of a state have enacted an initiative constitutional amendment that reduces the rights of gays and lesbians under state law." It's exactly Romer.
Okay.
So there may have been a line about that in the district court opinion. I don't know. I think the opinion was like 170-something pages long.
And Walker's opinion is much broader. And if you are results-oriented, and certainly most of us in this room have some results in mind, the Walker opinion
is a happier place to be the final word on this subject in this litigation. The Ninth Circuit was trying to aim at Tony Kennedy, citing essentially Romer back to him, and Walker's opinion goes a lot further. My own view is that for California, it didn't make a whole lot of difference which way it went, and indeed, if they'd reversed in Perry, it's pretty clear that California would have enacted a repeal of Prop 8 in 2014 anyway.
At the ballot.
At the ballot. So, but there's certainly guidance for the rest of us.
And in fact, I think there was some discussion as the case was going on about, I think they wanted to wait. I mean, some folks wanted to do a ballot initiative earlier to overturn Prop 8, and there was some debate about, well, do we want to do that? Because then that'll moot this litigation. We'd rather have this litigation go forward and possibly get a 50-state solution. And that was the choice they made. So I also want to know, some upcoming states that we might see movement in are Illinois, New Jersey, and Hawaii. And then I believe there still has not been a state where a constitutional amendment has been overturned, and so legislatively. And so states that are going to try to do that in 14 are Oregon, Nevada, and Ohio. So we'll see. Stay tuned on that front.
Florida. There's somebody now getting signatures.
Right. There's a group submitting Florida. As far as DOMA's effect in Florida, it's a quite complicated question, not DOMA's effect, the effect of this decision. So for purposes of federal law, each federal program looks to a specific place to determine whether you're married for the purposes of that federal program. For some federal programs, it looks to the place of celebration, meaning the place where you got married. For some other federal programs, it looks to the place of domicile, where you live now. For some other programs, it looks to other things, like the state with the greatest interest in the marriage. So the next question is, well, which programs look to which places, and how's that going to affect me? So their answers are not that easy. There aren't a ton of place of celebration provisions. One huge one for Florida is immigration. So USCIS will allow folks in Florida to sponsor now a partner to get a green card, provided that you can satisfy the other criteria for having a marriage-based immigration. So that's huge. But for many other provisions, it's either place of domicile or less clear. So for instance, for FMLA purposes, family and medical leave, which allows you to take sick leave to take care of a spouse. That applies in the private sector to employers with 50 or more employees. That's place of domicile, so you're not going to get that here if you work in the private sector. You could get public FMLA leave. But the good thing about that provision is that it's not statutory, it's regulation-based. And so we have a very friendly administration. The Judge Olson read a quote from Barack Obama, which indicates, I think, friendliness to this making these changes. And he's, I believe, appointed Attorney General Holder to start the process of figuring this stuff out. Because it's a regulation, his administration is going to be able to change that itself through a rulemaking process, through notice and comment. And so that could take some time, but at least it's something that doesn't have to go through this Congress. There are other programs where it's statutory, like for Social Security survivors benefits. That could only change through Congress, and so that's going to be much more difficult to change. So, other place of domicile provisions are Medicaid, although sometimes folks wouldn't want to file jointly. If you file taxes jointly, that could affect your Medicaid eligibility. Medicare spousal benefits, certain taxes, although that's a huge question. That's something you would want to talk to a qualified tax attorney about. TANF benefits, certain veterans benefits in certain contexts. The veterans benefits is even more complex because you get the benefits if you were married in the recognition state when you got married or when the benefits take effect. So it's not going to work if you just go to New York for the weekend and come back, but you would have to actually live in the state when you got married, and then you could move to Florida and get those benefits.
You mean, for example, burial as well?
If you mean,
Like
right, to get the benefits.
For veterans?
Yes, I believe that would fall
Because
under
that
that.
was something that was referenced in Kennedy's opinion. that
Right.
That's something that should be set aside.
Yes. Although I will say, I mean, I can't speak to that specific benefit, because even within agencies, the agency might have a general rule, like Social Security has a general, place of domicile rule, but actually specific provisions, might have another, might look somewhere else. So you can't say over, blanket statement that every single last Social Security rule is place of domicile. For instance, like SSI, supplemental security income, is generally place of domicile, but if there's exceptions for if you're holding yourself out as married, you could get that even though you live in Florida, but you would need to talk to folks
Steve?
who know about this stuff.
People think of domicile as being unassailably that place where you live. Domicile is a legal thing, and if you meet the criteria, which sometimes involves owning real estate, you can make out a case. You, for example, can make out a case, well, maybe not be, maybe
I got an interesting job for that purposes. Yeah.
maybe your job would be an issue with that, but the fact that you own a vacation house in Maine is the first toehold on,
Hey, Steve, how does Portland look?
I've actually assisted people in meeting legal domicile criteria in states other than the one that they spend most of their time in. So that your domicile isn't as given as sometimes people think.
If that wasn't picked up on the mic for purposes of the tape, Steve just made the point that the place where you spend the most of your time may not necessarily be your domicile for purposes of some of these statutory provisions, and that there are things, I suspect many things that those of us who are in this room are going to have to start thinking about that could create a domicile in a jurisdiction that would recognize same-sex marriage, if that's an important thing under the circumstances of an individual's case. One of the things that a less than perfectly sweeping Supreme Court decision on these topics leads to is a lot of future litigation, and for lawyers, that's not altogether a bad thing. Yes, sir.
You know, I'm probably one of the few people who was disappointed with the DOMA decision because I didn't think it went far enough. And if you look at Justice Roberts' dissent in DOMA, it makes it extraordinarily clear that this is not, as you put it, a 50-state solution, but it is really limited to a federal question as it relates to those states which haven't, in fact, adopted gay marriage. And it leaves out there in limbo states like Florida, which has a constitutional amendment. And then also, I believe it was a decision to deny cert on the Nevada case, where I believe it was a district court opinion which found that the constitutional amendment in the Nevada Constitution was in fact constitutional. So, I mean, it looks to me that it's going to take a number of years before we actually get that question back before the Supreme Court. And they sidestep everything very neatly as far as I'm concerned, and I'm really disappointed that they didn't get to the merits of the argument.
The question was, or comment more than question, was that by the clear language, at least in Chief Justice Roberts' dissent in the DOMA case, that this is not a 50-state solution and that this is deciding only the validity of marriage for federal purposes of those who are married in and perhaps residing in a state that recognizes same-sex marriage, leaves open an enormous number of questions I think that most of us in this room share that level of frustration. On the other hand, if the ratchet is moving in the correct direction, we can only hope that it continues to move in the correct direction. Does this case answer the issue for all time? No, obviously not. And as I said earlier, future litigation is obviously going to be required in order to fill in the many blanks that this decision left.
Because I want to open up for questions. I want to say something.
Yes.
Thank you, guys. Can we have a round of applause for our awesome speakers? Who had like, 50 something hours to digest these two opinions and did a really fantastic job bringing some great information to us. A couple things. You mentioned Judge Olson about all of the litigation that's going to come of this, and how a lot of this is great news for lawyers. So I just want to put in a plug that I don't think Daniel would say this, but because I know that you don't want to sound overly self-serving on the part of the legal organizations, but I will say, because I'm just a private lawyer, like, you're all great minds and you're outraged and you've been educated. And please don't go out and like start challenging DOMA in all of our courts and all of our trial courts without communicating and connecting with one of our national organizations that's doing this work. It's really, really, really important. I've already seen some emails flying about from lawyers who are like, I'm bringing a DOMA challenge, will you help me get some press? What? Because one thing that we learned this week is that we really like winning. We really like victories, and we've got the wind at our backs, and we've got some great momentum to move forward. But we don't want to have some of these cases brought that are perhaps not perfect. I mean, think about how perfect Edie Windsor is, and her story, and that was not just an accident. The ACLU carefully culled that case from many others, and this was a strategy where the ACLU and Lambda Legal and the National Center for Lesbian Rights, they all really came together and they worked together, and these are organizations that are just doing incredible work. By the way, there are a lot of questions that I'm sure people have about specific benefits. Daniel did a great job touching on some of the biggies. The national LGBT organizations put together about 14 fact sheets. They're incredible. They're really, really informative. I put them on my website, sobilaw.com. There you can go on Lambda's website, the National Gay and Lesbian Task Force, Family Equality Council, the National Center for Lesbian Rights, ACLU. Who am I leaving out? Oh, Single A GLAD, Gay and Lesbian Advocates and Defenders. They pull together a lot of really great information. And so these are the organizations for you to turn to if you have a great story, you've got clients with a great case. It's not to say no one wants to hear it and it's not going to be a great case, but don't just go all cowboy and come out, guns a-blazing and on your own. With all due respect to the memory of Ellis Rubin, we really do want to have, we'd like to try to kind of have some victories going forward, and there are people that know more than us, but not more than you, but about the strategizing and what makes sense to put our best foot forward, because indeed we got a great foundation with Windsor. We got some incredible language to work with. No one can understand, not the least of which is Justice Scalia, how you can possibly have a constitutional state-wide ban against gay marriage when you have an unconstitutional federal ban against gay marriage. So we certainly have some great opportunities here. So I wanted to say that. So good.
Ready, fire, aim is actually not the best way to
Ready,
approach
fire, aim.
to approach litigation strategy. It would be better if we could reordered those. So
Right.
think about that.
Exactly. We got to go across the hall and have cocktails, but certainly we can take questions. But I wanted to just take a moment. And is Ray Aberdeen still here in the back somewhere? there he is. Ray, come on up and say hi to everybody, because, you know, this program would not be possible, nor would the October program in Jacksonville, without the support of the Florida Bar. And we are here with the generosity of the Florida Bar. So Ray is a member of our Board of Governors, and we wanted him to just greet everybody.
Thank you very much.
Thank you all for welcoming me and letting me share a few minutes of my time. I am your Board of Governor from Miami-Dade County. I am one of 52 members of the Board of Governors. I came here last year and spoke to the organization, and I wanted to come here again, especially to let you all know that I am among many on the Board of Governors who understand your issues. And I want you to know those are my feelings, and there are others of us that have the same feelings. The President-elect, Greg Coleman, who could not be here, I don't know why, because I asked him to come, he shares my feelings about this issue very strongly for other reasons that are not important for this, other than to know. So the message that I wanted to deliver to you all is take advantage of us. Let us help you. Tell us what you want us to do. Tell us how to do it. Tell us what you want. We are listening. I am listening. Greg is listening. The board is listening. And we want to help. And we want to be part of whatever it is you want us to do. So I don't want to take up too much time, but I wanted to leave that message with you, and thank you for letting me speak. Okay.
As it happens, he's also hoping to run for president of the Florida Bar in a couple of years, so so we also want to hear from him for that reason. So questions? Silence. You've gotten so much information. Well, let me tell you one of the questions that people keep asking me this week. So my practice, I do LGBT family law. I make and break gay families. And one of the questions that people have been asking me, everybody's like, oh great, I'm off to get married so I can come home and get federal benefits. You understand that there are residency requirements to get divorced in most places, there's a residency requirement in Florida, right? So of course, there's 13 now with California. There's 13 states and the District of Columbia that allow same-sex marriage. And unfortunately, only California and the District of Columbia and Vermont will allow you to come back and get divorced there. So that's really just important information to share with you. And it's really awkward to share that with your clients and your friends when they're like, we're going to New York to get married. And you're like, could you just go to DC instead? Because not that you're going to get divorced, but of course it happens to other people, you know? So it's really awkward information to share. But, you know, you understand that what happens is that then they come back to Florida, or they move to Florida, they move to another non-recognition state, and they are what we call wedlocked. So I didn't make that up. I can't take credit for wedlock. But it's a really important phenomenon, and I didn't want today to end without just sharing that little piece of information. The little funniness with Vermont is that if you have kids, they won't let you get divorced there. So if your couple has kids or want to have kids, Vermont will not take back jurisdiction. It's a little confusing. So that's why really DC and California are ideal for all of our adopting and surrogacy clients. So that's that. I don't want to end on that note, so please somebody ask a cuter question, Robert Coleman.
Sorry, not a cuter question.
Oh, yes.
If you get married, say, in Massachusetts.
Yes.
And you want to get divorced, can you then go to California to do that or not?
No, but this is kind of like an interesting, weird concept, so work with me on this. Okay, right. California only retains jurisdiction to dissolve California marriages. Same thing with DC. That's why it's so awkward to tell people to go get married in the state where they can divorce. Incidentally, Illinois has only a 90-day residency requirement, Robert. We know that because we have a case. Yeah. We got some gay guys that are moving to Illinois. But no, California will only allow you to dissolve a relationship that you enter into in California. However, here is my idea. I don't know if this is going to work. I came up with this with a very good friend of mine is a San Francisco-based LGBT family lawyer, and this is such a kooky idea that I'm not going to tell you her name, but if you want to know it later, I will, because she's really smart. So what would happen if you went, so you're broken up, but you went to California and you went and got into an registered domestic partnership in California, or a marriage in California. And so then so you're broken up, but you go and enter into this thing as a broken up couple. Maybe this is fraud. In California, you can't use this against me in the court of law. But what happened? Right, exactly. Wasn't me. Right, exactly. You did say Leah. This is Leah Krause speaking. All those lesbians look alike. So what happens is, no, but isn't this true? That what would happen when you go back to California, what they do is, when California then dissolves what they do is they dissolve all of every status. California, when you divorce in California, it will dissolve that California marriage or RDP, and it will dissolve your Massachusetts marriage. So that's my kooky idea. And of course, none of this, they won't do any equitable distribution. I mean, the issue with jurisdiction over property and whatever, I mean, this assumes that you are not needing affirmative relief from the court in any substantive way.
Let me just put a little
Truth?
No, a little addition to that, and that is to consider when you're advising a couple about getting married, whether the disclosures that Elizabeth is suggesting you make of respect of the dissolution possibilities in California and the District of Columbia, that giving that advice might be prudent in light of future malpractice claims that might be asserted. You never told me that when I went to name a state and got married, I couldn't undo it.
Right.
So just think about that.
Right. Well,
Judge,
the problem
on
is
the bankruptcy question, how is this going to affect bankruptcy cases?
How will this affect bankruptcy cases? Well, most property rights questions are decided in the bankruptcy courts as a matter of state law under an old Supreme Court case called Butner. It's a very interesting question if there's an equal protection argument to be made. If a same-sex couple married in a jurisdiction where that status is recognized, then files for bankruptcy relief, are they entitled to file a joint petition in a state that doesn't recognize that status? It's certainly a federal question of filing a joint petition. B, are they entitled to claim certain kinds of property rights like tenancy by the entireties that are entirely a question of state law, and contend that by failing to let them assert a T by E ownership interest, that the state of Florida, to name one, is depriving them of equal protection. Those are very interesting questions, and someone will no doubt raise them someday, and then I'll get to think harder about it.
I love the malpractice. I love that statement, because the presumption is that your client has come and talked to you about it before, and I'm sure this doesn't happen to any of you, but I've got clients who do stupid things and tell me about it afterwards. So, but I love the presumption.
I never see litigants come before me who've done stupid things.
Exactly.
And then come to see me about them.
Right.
Are there any more questions? Otherwise, I suggest we all repair across the hall. This is an organization that obviously has its priorities correct. This is a 1-hour CLE and a 2-hour bar session.
That's right.